When we received the final letter from the Governor General on the 7th of February of this year saying that he couldn't inquire as to why 8,047 signatures were disqualified, one of the advice he gave us was that we should take it up with the minister responsible for the ministry, under which the chief elections officer falls, or the prime minister himself. As a result of that, Oceana, on behalf of the Coalition to Save Our Natural Heritage and all the petitioners and ourselves as an organization, we wrote a series of letters. The first one was on the 7th of February, in which we clearly asked Mr. Gibson, who was then the CEO of the ministry and responsible for the chief election officer, to answer 3 questions for us. Give us the names of the 8,047 people who were disqualified. Tell us for each one of them what was the reason for their particular disqualification, and also inform us as to whatever rules or procedures they put in place to determine how the disqualification process is to take place. We never got an answer. Subsequent to that, there was a telephone conversation between myself and Mr. Gibson on the 16th of February, in basically which we said, you know, what is the latest? And he said, well, we're seeking legal advice. I said, can you give me it in writing, because we want official records. So you have a letter there in which he says, okay, we're seeking legal advice. But then we didn't hear anything. So on the 15th of March, we wrote another letter and said, well, you know, it's almost a month. What is your response? And still nothing, no, not even a telephone call, nor a letter as a result. And we still waited thereafter until the 2nd of May. We sent the final letter and said, you know, when you announced on the 2nd of February at your press conference that these people were disqualified, you had to have had at minimum the names of each. Can't you at least release that to us? And we still haven't had any answer. But you have to understand that what Oceana has done is we have filed an application to the court asking them for permission for judicial review. Under the legal system is you can't just go and say we want judicial review. You have to get the court's permission to initiate this process. A lot of people might ask, what is judicial review? Judicial review means just what it's saying literally. Judicially, meaning a judge, a court of law, will review the decision of any public authority, body, or person acting as that public entity, review the decision. So we are saying we're asking permission to appear before the court to question the way they determine who were these 8,047 people who were disqualified. That's what it means.
Well, they themselves at their press conference admitted to the public that they were working by no expert advice or experience, that they just had to basically use discretion in eliminating signatures.
Mm-hmm. Well, you see, that's what they said at a press conference, but we believe in official channels, and even when they decided to do that, it had to be under some rule, direction, or procedure. I don't know if there was an internal memo or whatever. It had to be that there had to be some standardized decision or policy as to how they would deal with this matter.